Let's tease this out a little more in the next case we're going to review. That's People versus Gauze. It's a landmark case for the state of California, and other states have taken note of it as well. And from my perspective, it's a special case because Justice Mosk wrote the opinion. Justice Mosk was one of the longest-serving justices on the court, extremely well respected, and a graduate of Southwestern Law School. People versus Gauze reminds me of those gunslinging westerns like High Noon or 357 to Yuma. Two guys face off on a dusty street in the middle of town. Only here it's their apartment. Defendant and his roommate Miller get into a horrible fight at a friend's house and concoct a harebrained scheme to arm themselves and meet back at their own apartment to duke it out. Whose planet did this seem like a good idea? Anyway, Gauze borrows a gun, hightails it back to the apartment. Roommate Miller is waiting in the living room for him, and immediately Gauze points the gun at Miller and shoots him in the side. Before we launch into a discussion of whether Gauze should be guilty of burglary, do you think he could be guilty of attempted murder? Let's remember what that crime would require. Attempted murder would require sufficient acts towards a murder, coupled with the specific intent to kill. If you were a prosecutor, could you argue that Gauze has the specific intent to kill? I think you could. He points a gun directly at someone, pulls the trigger in a very close space. It looks like he wants that person to die. I think we could think he has intent to kill. That's a natural and probable result of pulling the trigger at someone at close range like that. The fact that Miller didn't die is great news, but Gauze could have committed attempted murder by that act. So now to the question at hand. Justice Mosk tees it up immediately. I think that's great opinion drafting. Can someone be guilty of burglarizing his own home? If we think of the main underpinnings of burglary, we come quickly to realize that the answer's got to be no. First, the court says that burglary remains an entry which invades possessory rights of a building, and it still must be committed by a person who has no right to be in that building. No matter Gauze's intent before he walked into his home, it's still his home. He still has that possessory right in his home. Miller can't take that away from him. So Gauze shouldn't be subject to burglary charge of his own home just because he had a felonious intent when he entered. Second, possibly a little more subtly, this is not what burglary looks like. We've already talked about that. Heart-stopping nature of a stranger coming into your home. Well, the court confirms that feeling. Look at the court's statement towards the end of the case. The court says, in contrast to the usual burglary situation, no danger arises from the mere entry of a person into his own home, no matter what his intent is. He may cause a great deal of mischief once inside, but no emotional distress is suffered, no panic is engendered, no violence necessarily erupts merely because he walks into a house. So we see panic in both situations, but they really derive from two different sources. Here with Gauze, yeah, Miller's panicked. He's panicked because his roommate's got a gun and he's going to kill him. But the other case, the case where burglary really arises, is where a stranger has entered your home to commit a felony. It could be to kill you, but it could be to commit theft. It's that entry by the stranger and that panic that we're really trying to stop. The court used a great hypo at the end of its case. Did you catch it? I loved this hypo. We call this in the law parading out the list of horribles. It means an argument that's reduced to the absurd, reductio ad absurdum. You've already seen this drafting tactic in People versus Decina, where the dissent trotted out a whole list of absurd results that could happen if the majority's decision were to be applied, where our man operated the motor vehicle while engaged in a seizure. The court does it here at the end of the opinion with a terrific example, which is equally absurd. It says that if we allowed a burglary charge for owners, look what could happen. Court says the burglary could include someone calmly walks into his own home with an intent to forge a check. That wouldn't make any sense, and it didn't make any sense here in Gauze. Now that we have the rule down, I want to examine how the court got there. Let's look at its analysis. Look at the court's review of burglary. First, it started with the common law and then moved to California's modern view. This is an excellent example of how a court must interpret a statute. The court first acknowledges the common law definition of burglary, then considers the changes the legislature undertook, and then interprets the reasons for the changes. The court says the legislature preserved the spirit of the common law definition of burglary. Preserve the spirit of the common law is a great term, and in the case of burglary, it's true. We started with the seed of burglary at common law, and then you can see the changes that were made modernly. Despite some changes, at its heart, burglary is really about the lack of invitation to enter, coupled with the felonious intent at the time of entry. And all the state statutes really look this way, minus some differences.